and welcome to another offering in the New York Law School ADR Skills Program series of continuing legal education programs. We're very honored to have some specially talented and specially experienced people with us today to address the intricacies of the mediation process or other settlement in personal injury claims. I'm particularly happy that I finally, after all these years, roped in a friend of mine from my law school class, Craig Rothenberg, who is so successful as a personal injury lawyer that it's just very, very difficult to get a hold of him. But here we are. We have an opportunity to spend the next hour or so with Craig Rothenberg and his superb colleagues. So, Craig, would you go on ahead and take it away?
Absolutely. Thank you, Peter. As Peter told you, I had the privilege of attending law school with him. And of course, as you're all aware or should be aware, that is New York Law School. So it is rather gratifying to be able to speak to you today in connection with a program that is sponsored by the law school. As Peter told you, I am a plaintiff's personal injury attorney. That is what I do. Occasionally, I'll take on a case of discrimination or something incidental or ancillary to personal injury, but exclusively, in my mind, I handle cases involving medical malpractice, industrial accidents, construction accidents, sometimes trucking or car accidents if the issues are interesting enough and the injuries are severe enough. We maintain a very, very small caseload in my office, typically handling cases that are valued at 7 figures or more. I've been doing this for 35 years, and thankfully, hopefully, I'll be doing it for another good number of years. We have with us today retired Judge Jamie Happas. It is absolutely a privilege to have her here. During my career, I had the opportunity to appear in front of Judge Happas on many occasions. It was always a productive experience and a pleasant experience. For those of you in practice, you know that it is not always pleasant to appear in front of all of the members of the judiciary, but I can say that Judge Happas always ruled with a very even hand and a very good understanding of the law. And when you had a case in front of Judge Happas, you were always guaranteed to get her best efforts. Since leaving the bench, she has been a mediator for me on a number of cases, including the case study that we presented to you today in the materials. Unfortunately, there's a lot of redactions there. Hopefully, folks can get the flavor of it from the materials submitted. I think it's a pretty interesting case. And I thought it was a rather appropriate case to discuss today because one of the defense attorneys who was defending the case is my colleague, Gary Riveles, who has also agreed to join us here today. Gary is a founding member and partner of the law firm of MacNeill, O'Neill, and Riveles and Spitzer. And he is a fabulous lecturer who often speaks on the issues of medical negligence. And he is one of the authors of the most important book in my office, which is the text involving New Jersey medical malpractice law. He is a go-to guy among the members of the bar on both sides. People know they can always call Gary when they have a question about the substantive issues of law involving medical negligence, and he is one of the experts in the state of New Jersey. I'm hoping that the discussion we have with you today about the case that we were involved with is helpful. I'm not sure what the level of expertise is of the various people who are listening to our presentation today, and hopefully we will keep it interesting and, as I said, productive. Having said that, Your Honor, or Gary, are there any introductory statements you'd like to make before we start?
Well, thank you, Craig. It's my pleasure, my honor, actually, to sit on this panel with both Craig and Gary. I've known them for many years, and they really are the best of the best. So I think you're gonna be able to walk away with some very important things to remember in your mediation practice and how to succeed with mediations. Mediations are something that you should always have in your toolbox. You know, I'm a true believer that trials are irreplaceable in our system of justice. But, with COVID and case backlog, whether you're practiced in New York or New Jersey, mediation should always be considered, to be a tool that you should use in an attempt to try to resolve your case. I'm a true believer that every case is settlable, right? And if not, right, we have our jury system. We're very lucky to live in this country where we have jury trials. But, if you do decide to, put your case into mediation, it's important to remember, several factors. First of all, you want to discuss that with your adversary before the trial date, okay? Because remember, you want to pick a mediator, first of all, who you feel comfortable with, who you trust. And, most likely that mediator may be scheduling, 3, 4, 5 months out. So, it's probably, especially if you have a very complex case, to discuss that early on with your adversary, to see if maybe at some point in time of the discovery, whether or not mediation would be appropriate. And, there's two trains of thought. Do you do it earlier on in the process so you don't spend time in terms of discovery, or you do it later? Well, it depends, right? I mean, some carriers and some adjusters, they want their lawyers to dot every I and cross every T. So that's something that you need to consider when the timing and when it's appropriate. But I think mediation is very fruitful, and you also have to remember whether you're representing the plaintiff or the defendant, it's that party's day in court. So I think it's very important that, you find a mediator too that allows your client to be heard, because, you ultimately want to settle your case, but they should be heard. And the mediator should give them the time, to speak and to talk. But hopefully we'll get into more of the nitty gritty, with Craig and Gary.
Gary, any comments before I start talking about our case study?
No, I would just say it is a very interesting case. I did have one of the defendants, although not the primarily responsible defendant, but certainly one of the responsible defendants. And I think the nuances of this case and how it ended up at mediation, how many sessions it took at mediation, are illustrative of the process that we go through. Thank you for the comments, by the way, Craig and Judge. Always a pleasure to be on any panel with you or to be with you. So thank you both.
So at the outset, I think what we should understand is that mediation is a part of the process. As I tell all of the young associates in my office, if you get to the point in a case where settlement is possible, settlement is not an event. It is a process. It is doubtful you're ever going to get a case settled proper, at least a case of significance settled in a day. There are a lot of things that have to take place. Mediation may be part of it. It may not be part of it. As we're sitting here today, I have 4 or 5 significant cases in the midst of mediation. Some of those mediations have lasted as long as 9 months by my calculation. And Judge Happas was kind enough to help us recently resolve a case where we went through, I think it was 4 sessions over the course of 9 months to get the case resolved.
It was crazy. And it got to the point where, because there was coverage, lots of different layers, all right? You have coverage issues and the like. And one of the defense coverage lawyers, because I was, on the phone at 7 o'clock at night, early in the morning, and the lawyer made a comment like, I think my wife thinks we're having an affair. I said, no, trust me. You tell her that we're not. But it was just that you put a lot of time into it, and it's important. And I think clients have to understand that it is a process, right? And despite the fact that I'd love to settle a case the first time, and a lot of times I do. I mean, complex cases take time because there's so many different facets, but it does take time, and it's very rewarding once it's accomplished.
So the case we're going to talk about today is a case where we were contacted by the plaintiff, and he had been diagnosed with terminal cancer. And then about 2 weeks, 2.5 weeks later, he was told he didn't have terminal cancer, and that he had no illness whatsoever associated with the negligence of any physician. And so it was an interesting case to decide whether we wanted to take. Essentially, we were going to represent somebody who was not ill, had not been ill, was not afflicted with a disease. He was just somebody who, for what appeared to be 2.5, 3 weeks, was under the impression he had cancer. And we thought about it, and we thought about what that means in terms of somebody's life and how it can affect them. And we talked to the plaintiff extensively to see whether, in fact, he was suffering in any context, even though he was no longer under the impression he had cancer. And we decided that it was a case that was meritorious for a couple of reasons. Number one, we decided the liability issues were not going to be particularly complex or expensive to submit to a jury. And that, of course, is a consideration in every case we take. It has to be financially viable. And then we thought about it, and we decided that the damages would justify the work that needed to be done on the case in terms of the limited liability issues. And so in that particular case, we initially sued 2 nurses who were responsible for the tissue sample that went to a pathologist being marked incorrectly. We sued the doctor who was responsible for the tissue that was taken, and we sued the pathologist in the case, and ultimately let the pathologist out of the case. And then we proceeded with respect to the claim against the nurses and the doctor. Shortly after we filed suit, the nurses conceded that they were in fact negligent, and then the issue became whether or not the doctor was also negligent, and an expert report was proffered with respect to that issue. And then we provided a report with respect to the damages, which were essentially primarily psychological, psychiatric type damages, although the patient, the plaintiff, did have an additional unnecessary procedure. It was a very minor procedure. We had a small biopsy taken. And I will tell you that Gary and I had some discussions early on about value, because his position was, as was the position of the other defense attorneys, that my client should be happy he didn't have cancer. My position was, you gave my client cancer, and for 17 days, he lived with cancer. And the fact that you ultimately were successful in making him not have cancer doesn't mean he didn't live with it for 17 days. And in fact, he modified his life. He made a decision not to get involved in a business deal. He lived silently with the affliction, not telling his family, because he knew, based on what he was told, that he was going to die. He started seeing other doctors to get opinions on the next course of treatment, which was apparently the removal of his bladder. And in fact, he was sitting in a doctor's office when he got the call from the defendant's office telling him that he, in fact, did not have cancer. And so we had a debate over valuation, and we talked about it for a very long time. And ultimately, we got Judge Happas involved so that we could discuss it with a neutral party. So somebody could either tell me I was crazy or Gary was wrong. Notice Gary's not crazy, and I'm never wrong. And so that's how the process began for us. And Judge, I don't remember in this case, I think we had more than one session, didn't we? Judge, do you recall?
I don't recall. I don't remember.
I do. So let me just give a little bit of background from my side. So I'm hired by insurance companies, and I have a fiduciary duty to the doctors I represent. My doctor in this case was particularly challenging. He was a challenging personality whose position was, if there was a mistake, it was the nurse's and not mine. Although his name, he has to sign the pathology sample that goes to the tissue sample that goes to pathology, but it's given to him by the nurses, and the nurses apply a sticker to it. And what ended up happening was that day there were 2 surgeries done by my doctor, and they combined the tissue and sent it down essentially as one sample. So there was only ever one pathology report. And convincing him that he had any role was challenging. Convincing the insurance company, who absolutely took the position that this patient should not have sued, he should be thrilled that he did not have cancer, albeit thought he did for some 17 days. And so New Jersey, much like New York, in most commercial insurance policies, they have a consent provision for the doctor. And if the doctor doesn't sign the consent, that case is going to get tried because the insurance company cannot settle it without the doctor's consent. In this case, it was only after Craig, Mr. Rothenberg, took a very skilled deposition of my defendant that we were able to secure his consent. But the reason we had multiple sessions is in a very unusual circumstance. Normally, when you sign a consent, you consent to settlement up to the policy limits. In this case, I think there was $1 million limit. But my doctor refused to consent to that. His position was, I'm only going to be responsible for 10%. And the insurance company allowed that to happen, which never happened. I've never had that happen before, that he would pay 10% of any settlement. So if the settlement total was 100, he would pay 10, and the other defendants had to pay 90. There was no agreement between me and the other defendants who admitted their culpability as to a percentage share amongst us, but it was to their advantage to argue that my percentage was significantly higher than just the 10% that I was allowed to participate in. So we went through a day of mediation with Judge Happas where they didn't have enough money and my 10% didn't really matter because they didn't have enough money to get it done. And so it was after that session that, and it was a good while, many conversations, some of which occurred at 10 o'clock at night at the doctor's office between me and the doctor, to get him to agree to a full consent up to a dollar amount as opposed to a percentage amount. And then there were multiple phone calls between the judge and both lawyers and all the lawyers. And ultimately, we did have another session that was much more productive.
Your Honor, before you talk, I just want to add that describing a client as challenging might be a bit of an understatement. As I recall, one of the issues in the case was he took tissue from a patient which did not include any bladder and got back a pathology report that included tissue from a bladder. He had no reason to believe that this patient had cancer. He got back a pathology report that said cancer. The tissue sample that was taken from the man was 1/7 the size of what was reported in the pathology report. And I believe in deposition, Gary's client admitted that he never actually reviewed the pathology report in any great detail, but still thought it was a little bit off and waited 10 days or so to tell the plaintiff that he had terminal cancer. And certainly in those 10 days, he had ample opportunity to call up the pathologist and say, hey, let me ask you a question. What happened to the other sample from the other person I biopsied that day? So
who was known to have cancer. The other patient was known to have cancer.
Yes, that's right.
Terminal cancer, yes. And so putting aside his testimony, and thank you, Gary, for the compliment, but I don't know that it was me that ran that deposition so much as your client.
He called you an ambulance chaser, as I recall, during the deposition. So.
I do recall that I asked him the following question. He said my client was being greedy or something like that. And I asked him whether that was his pathetic opinion or if he had any data to back it up. And he answered by saying it was his pathetic opinion. And I think that was a problem. Anyway, so, notwithstanding the problems he was giving Gary about participating in the settlement, there were real liability issues that fell upon his shoulders. And from my perspective, in every case where I'm trying to get a global settlement, I don't care what people are contributing and in what percentages, if it's a global settlement. So I was feeling Gary's pain because it was translating into my pain, because it was a case which absolutely should have resolved. And Judge, I think you probably shared that opinion from the beginning.
Yeah, and I felt the pain too. I think it's really important if you have a difficult client or a difficult adjuster, I think it's beneficial to you to share that with the mediator in confidence, okay? Because, the mediator, then I really know how how to react in each separate room, and let me be the bad guy, right? Let the mediator be the bad person, because I can say things that you may not be able to say, right? And I will be more forceful if I know that you really have a difficult client and they have to hear it from from a third party, who has no skin in the game. And that's what I say. I have no skin in the game, and I would often say I have my voice back now. I no longer have to listen to the administrative officer of the courts, who are bean counters who want me to sign their case out to trial. I just want to settle your case, right? So I can be open, and I often say that I'm not a shrinking violet, right? And that I'll give you my opinion. You're paying me for my time and my experience. And if I know you have a difficult client, I'll act accordingly. And it's important, when you have issues like this in mediation, a lot of times you have to treat, each defendant and the parties all separately. And sometimes you can't come up with, global numbers. You have to really act separately in each room. And you have to trust the process, trust the mediator in terms of trying to put together some type of package. And everybody felt bad for Gary in that case. That we really, because everybody knew that really his hands were tied. And but it works out. Sometimes you just have to muddle through.
If I may, before we go on, we're having a really good time as far as I'm concerned. Those of you who have been around the block in these online CLEs before know that pursuant to the courts of New York, we have to demonstrate our continued presence and participation in order to get our CLE credits. And in order to do that, I'm going to be giving 3 code words. The first code word is personal. Personal. And I'll give another code word in about 30 minutes, and then again at the very end. Also, I want to remind you that there are so many people on. We have 52 people who are online, so it's our custom not to have participants, asking questions or raising issues or things like that. And if you have a question for one of the 3 speakers, put it in the chat room. I'm watching the chat field, and I'll make sure that those questions are raised to our speakers. All right. By the way, I have a question of my own, if I may. I was really impressed by the detail of the supportive evidentiary information that was in the mediation submissions, compared to the kind of business mediations in which I engage. It was really fulsome submissions. Gary, is that common that there are exhibits after exhibits after exhibits of testimony and deposition and expert reports and so on that are submitted?
It is, because these cases are complex and there's a lot of data, and it could be buried in any one of those things. So we do try to give a full flavor to the mediator of what is supportive of our position. And look, we try to discount what's not supportive of it, so we give them that too. But I always think it's wise to put all your cards forward and try to get the information out there for the mediator to see.
And what was interesting about this case, Gary, is it was a relatively simple case. And if it was ever tried, there wasn't going to be a lot of demonstrative evidence, because you can't demonstrate in any real way what the plaintiff was experiencing. So in that regard, the submission is actually a lot, from my perspective, it was a lot simpler than what I typically present. I always include photographs, video, etc. I'm in the middle of a mediation right now involving the unfortunate passing of a woman from colon cancer. And we have 2 bits of video that were submitted with the mediation and will be presented at trial. One is a video of her teaching residents in a medical school of what it feels like to have a terminal illness. She happened to be an advocate for people with certain medical conditions. And when she was diagnosed, she was asked to give this speech to residents, and we've got it on video. It's about 45 minutes. And toward the end of the conversation, she gets into what it's like to be misdiagnosed and know you're terminal. And then we have another bit of video, which was taken during the last 9 months of her life in small increments, of her husband videotaping their conversations about how she was feeling on any given day, including days where she felt great, until the last day when she was begging to be killed. And so we present all of that to the mediator, just like we would if we were going to try the case. This case, again, was rather simple. There wasn't much to show other than some documents. So in our words, we tried to describe what the plaintiff was going through. And of course, we had the benefit of a very articulate fellow who came to the mediation, and Judge Happas had the opportunity to meet him and talk to him and judge whether or not he was credible in what he was saying. And I certainly thought he was. So we also have the people involved. To that point, Judge mentioned earlier that sometimes it's helpful for her to speak directly with one of the parties. My position on that is I never want the mediator to speak to my clients. If I haven't convinced them I know what I'm doing by the time we show up at mediation, I haven't done my job. And so...
And I agree with you there, Craig. I just think that at some point in time in the process, and you and I have worked together long enough, it's just not even to speak to them, but to let them become part of the process. Because, as you folks who have mediated know, you're back and forth, you're in and out of the room, and you're calling the lawyer out. And, I tell the plaintiff right up front, I said, listen, this process is going to consist of me talking to your lawyer, calling the lawyer out of the room. We're not in cahoots. I'll always be here to answer your questions. But I'd like to, at some point, especially if the day is dragging on, just to go in there. And I will always, always, always tell the plaintiff's lawyer what I'm going to present and say, okay? Because I will never, ever make a lawyer look bad. The goal really is to make lawyers, whether the defense lawyers or plaintiff's lawyers, look good in front of their clients. Because let's face it, right? We never as lawyers, get pats on the back. And, but sometimes they just want to talk, and I have to let them talk, and I'll tell them, whatever you say here is confidential. If I think you're saying something that would help your case, I'll turn to the plaintiff's lawyer and say, can I use that? But I just find it helpful sometimes, because then from a mediator's point of view, I think that if I can get, and Craig, I don't want your head to get big, but you're better than some other plaintiffs' lawyers where you do have control of your clients and the like. There's some plaintiffs' lawyers not so much, and sometimes they want to hear from someone else who's not involved in the matter, just to see if they're going to be making the right decision. I just want them to feel comfortable, and if I can get them to trust me and to trust the process, I think I have a better chance of getting the case resolved.
I think that's probably true. And Your Honor, I have a lot of experience with you, and I trust you both implicitly and explicitly. But I recently had a mediation where a mediator who I had not appeared with before chose to speak to my client in a way which made her incredibly fearful that she was going to get no money.
Yeah, see,
that she was going to, be out on the street, left in the cold. And that the defendant, who was threatening to pull the offer, was literal in their intent. And I tried to explain to my client that she was in no different position walking out of the room than she was when she walked in. And the case didn't go from being worth $3.5 million to zero because she turned down $3.5 million, but she was despondent because of the way the mediator put the fear of the mediator into her.
Yeah, that's
and so I was required after the mediation, and in fact, the offer was pulled. I was required to go and negotiate in a way which I typically wouldn't. And I ultimately got the case resolved for about $4.5 million, proving my point. But I believe I would have gotten a much better result had the mediator not injected that level of fear into my client. And I told the mediator as such. I took her aside and I explained to her that I thought she did a dreadful job in that regard. And I got pushback, and we agreed to part as friends, and I'll never use that person as a mediator again. I think it's very important to have client control and client education. When I walk into a mediation, my client is not confused about why we're there and what my position is. I understand sometimes the doctor is a little more strident and Gary has got to deal with personalities and professional issues. But I've got a personal relationship with most of my clients. Anyway, I was given a question that Peter wanted me to address, how I try to move settlement along in cases which are not going to be mediated successfully, what techniques we use. So I don't know if I'm a typical person when it comes to this, and I must admit that the COVID pandemic has changed my thought process a little bit. But I've always believed that I'm a trial attorney and I try cases. And if the case settles, so be it. But the way I settle cases is get ready to try them. And most of my cases settle. Now, of course, with the delay that has been injected into the court system because of the pandemic, my clients don't necessarily have forever to wait. I've got one case which still hasn't been tried, which is 11 years old. And one of my experts, because the case is so old, just had a stroke, and now I've got to replace the expert. And so I've tended to try to look at it a little bit more generously in terms of my attempting to settle cases without waiting for a trial date. And so there are certain things we can do. For instance, there is something called an offer to take judgment, offer of judgment in New Jersey, where we can throw out a number to the defense, which should inspire a conversation with their carrier and their client, although it doesn't always. And that rule is meant to inspire settlement discussions. Sometimes it's successful. There are certain cases in New Jersey where bad faith is implied if insurance companies don't settle within policy limits, and sometimes we'll send out letters which invoke that particular case law. The primary case is a case called Riveles Farms. And, you know, if people are in a position where they understand it's a case which should be resolved, that might inspire a settlement discussion. But historically, to me, the greatest assistant to settlement is a jury. It's either going to get tried or it's going to get settled. We're here. Let's do some business, or let's try the case. I don't know if I answered your question, Peter. See if we have any. Do you have any thoughts on that, Gary? How to promote settlement in the absence of a mediation?
Look, I'm not a warpath lawyer. I've never been a warpath lawyer. I'm a guy that gets along with both sides. The book I write with two plaintiffs' attorneys. I think the way I get cases resolved that should be resolved is I pick up the phone and rely upon my relationships with my adversaries. Many of my adversaries are personal friends. Certainly all of them are at minimum acquaintances, unless it's somebody new or somebody from out of state, which we do get some attorneys from out of state who I don't know. And those are always a little bit harder. But I leverage my personal relationships with my adversaries. And when I think it's time to try to resolve the case, and sometimes that's before depositions take place, and sometimes that's right before trial or during trial. But when I think it's time to resolve a case, I'm always open to the conversation, but I have to get a lot of ducks in a row. I got to get consent from my doctor. I got to get the carrier on board. I got to make sure the carrier's reserves are high enough or in the right ballpark for the settlement. And if all of those things align, it's often either a conversation or a mediation. And we're lucky in New Jersey that there's a good number of very talented retired judges who handled both in practice and as a judge the types of complex cases that we deal with. And most of us who do malpractice law have relationships with these judges. I know I worked for a lawyer for 30 years or for 20 something years before I started my own firm. And that lawyer knew Judge Happas very well. And I always spoke very highly of her. So I always knew when I was going to appear before her in Middlesex County that I was going to get a fair shake. And judges like her that are now retired and facilitate resolutions are great for us because they know both sides and they know the issues. So it's very, very helpful. But oftentimes it's just a phone call.
And that's exactly it. It's all about communication. And I think we're losing that as we go forward. And part of it is the way we're training some of the younger lawyers, right? I mean, they weren't trained the way we were, Craig and Gary, and those more experienced people that are on this Zoom. And you're a man of your word, right? So you deal with these lawyers, and they know that if Gary's or Craig aren't talking settlement yet, because it's not ready to talk settlement, right? But if you pick up the phone and you talk to people, that's how you get things resolved. And you keep the lines of communication open and don't get rattled. I mean, Craig is there's a handful of plaintiffs lawyers that I know that are really just cool and collective. Defense can come in and they can say, listen, we have nothing or whatever. And it could be like a big waste of time for the mediation. But you know what? They said, okay, we'll try the case or we'll move forward. Like they don't, but there's other plaintiffs lawyers that'll rant and rave and, slam their books down and, do all the nonsense, which there's really no need for. I think you get more with honey, than otherwise, in this profession. And if you keep those lines of communication open, that's how you settle cases, and you get the reputation as a lawyer, of settling cases that way.
I maintain as good a relationship with every attorney that I litigate with as possible. I think it's important. I miss the days when there was a placard outside of every courtroom with the rules of etiquette as to how we're supposed to treat each other. I think that is critical to the professionalism in our work. Having said that, that doesn't mean we can't be tough. It doesn't mean we can't be strident in our positions.
That's right.
I'm about to have a discussion with a bunch of defense attorneys in a case I'm handling, where my client is just had a scan which showed she probably has a reoccurrence of cancer. And my message to those attorneys in the meeting is going to be very simple. Settle the case while she's alive, or I will not settle with you at all. Because I want her to get the benefit of the money, not her estate. And if they can't get this case resolved with the level of information that's already been exchanged, shame on them. And I mean it. And they know I mean it. And so, is that a threat? Is that war, Gary? I don't know. But that's the way it's going to be approached, because my client is entitled to be compensated for what they did to her. And I won't bore everybody with the details of the case, but I will tell you from my perspective, as many of my cases are, it's not defensible. It's an issue of which of the defendants are going to pay how much. So I'm sorry to interrupt. Go ahead.
I was just going to say, but not every case is as clear. I mean, certainly no case when it walks into your door is the same when it goes to trial or when it goes to mediation. Every one of the cases that we have evolves over time, and issues that you may have thought were important at the beginning are not so important at the end, and different issues arise. So I think some cases are less black and white and more gray. And those gray cases, they're the ones that are harder for us to come to an agreement on valuation, because I may say, look, your damages are great, but the liability is not so great. So we need to compromise what full value would be compared to what the position is. Those are all things that we have to take into account. And Peter just asked me to address one issue. There was a question raised about if we default to judges as mediators, and do we have go-to mediators from our experience? I will say this: I have mediators that I won't use. And the majority of mediators in New Jersey, there are a few lawyers, and there are a couple lawyers that I do use as mediators. But I tend to see I probably mediate 15 to 20 cases a year, and I probably mediate with retired judges 3/4 of them. And I probably see the same mediators over and over again, once or twice a year. It's not just me who makes the decision. It's a collaborative decision amongst all the parties in the case. And so some some have opinions on one mediator versus another, and sometimes it's hard to come to an agreement. Each will put out 5, and there'll be no agreement amongst those 5. So it really depends on who's involved. But I would say, Judge Happas, who's here, and there's probably 3 or 4 others that I see the most regularly of any of the judges.
We're lucky in New Jersey. There's a lot of very good mediators and retired judges, but everybody has their own style, right? And some people may not like my style as compared to, the next person's style. I tend to be more interactive and, try to give my opinion. I just don't go back and forth into each room and say, okay, they're here. Okay, where are you? And then go back, well, where are you? You can do that on your own. You don't have to pay me to do that. Okay.
Mediation is not bracketing.
Right, exactly. But you know what? It's a style, and you have to find a mediator whose style that you can live with and that you like. And you have to find a mediator. I always tell in my opening remarks that I say that mediation is a process, and I give an example during my opening remarks. And I say when I was a young lawyer, I was given a settlement conference to go on. And I thought I was cool because I clerked for Judge Breikoff, who was the assignment judge the year before. So I knew all the judges. So I go into this particular judge and he says, well, what do you got? I said, well, the adjuster's got $25,000, but they only want me to offer 10, right? I go out, plaintiff goes in, plaintiff leaves, I go back in, the judge looks me straight in the eyes and says, they won't take your 25, right? So I'm like, oh my God. And I have to go back to the senior partner I work for and hope I still have a job. Moral of the story is I still had a job, but I learned early in my legal career the judges you can be open and frank with, and some not so much. Not that they weren't awesome judges. So I give that story during the beginning because I say, you know what? There's going to come a point in time where I'm going to need you to trust the process. And I'm going to need you to trust me. And quite frankly, if you don't trust me, you'll never use me again, nor should you. Okay. And I'll say at some point in time, I may say, listen, hypothetically speaking, if I can get them in this range, do you want me to continue working? Because I am not the type of mediator that's going to come back in the room at 3 o'clock after I feed you lunch and say, you know what, it was really nice to meet everybody, but unfortunately it can't be resolved. If I know you folks are in completely different ballparks, I'm not going to waste your time or your money. So, but some people might not like that style. Okay, so you do getting back to the crux of the question, you have to find someone whose style that you like.
I would like to say Gary was correct that every case is different and we have to approach it differently and figure out what the strengths and weaknesses are. And I did not mean to imply that I would negotiate in every case like I will on the case I was discussing earlier. But I have one major flaw as an attorney. I actually believe in all of my cases. And so it's very difficult for me to enter into a discussion and acknowledge that there is any weakness, even though I know there are weaknesses. And I think that blindness is probably one of the reasons I'm able to resolve cases the way I do, because I am not afraid of the weaknesses. I embrace them and I factor them in. And then I still try to get as much money as possible for my clients. One of the questions that was asked in the section was how much of a haircut I would be willing to take to get that client paid while she is still alive. And that's a very interesting question because we work in an area where there are no absolute numbers that we can say a case is worth in most cases. And so what I tend to do in a circumstance like that is I figure out what the appropriate range of settlement would be. And if I'm feeling particularly generous, and most of the time I'm not, I'll take the lowest number in the range, but usually I shoot for something in the middle. Well, what I won't do is hold out for the top dollar in the range. Now, in that particular case, it's going to be an interesting conversation because my client's expectations are actually very significant. And so I'm not so sure she's going to take my advice, and I'll do whatever she tells me to. But if they don't have that conversation, we're going to have a problem. I think I answered the question. There was a follow-up here about whether or not we go to whether we go to non-binding arbitration. Typically, our arbitrations or mediations are not non-binding. Occasionally, we will submit to a binding procedure. in those cases, it's typically because there is a limitation on value or there is a real weakness to the case from my perspective. And since I'm vetting my cases very carefully, that rarely happens. Gary, do you go to non-binding scenarios? I'm to binding scenarios?
I typically do binding binding arbitrations with a high low in place, and I typically suggest them to my adversary in a case that I think I am going to no cause. And of the 20 or so ARBs that I've done, I no caused everyone but one. And the one that I didn't, I thought the judge got it wrong. So I do offer them on occasion where I think a case is going to cost me a ton to try. There's a downside risk, but I think I would win it well more than 50% of the time. But my adversary has to understand that, because the low is going to be essentially their costs, and the high is probably going to be mid-range on what the case is worth. But as I said, I've had about 20 of them, and I no cause 19 of them. And I think I was going to no cause them at trial too. So in that way, I protect my adversary a little bit. I at least protect their costs. So,
Gary, am I right that when you engage in that sort of process, there's less of a consent issue?
there's a different consent issue. So I still have to get consent, but it's a different form of consent that authorizes them to settle up to the top of the, to resolve the case between the numbers that are out there. So it is different, but it is easier to get, because the one benefit of an ARB is if I do no cause it and the carrier pays the low, there is no reporting to the data bank and to the State Board of Medical Examiners, because they haven't paid as a result of negligence. They paid pursuant to a contract. And so that's a very beneficial way for me to get consent if I'm confident I'm going to no cause it, because there will be no report for the exchange of money.
Whereas if you simply settled it for the same amount, there would be a report.
Correct.
Right. So I had one of these binding arbitrations, and we did it as a high-low with a baseball style. So damages were not discussed. We either won on liability or we lost on liability. And the numbers that we agreed upon before the arbitration were $450,000 and $850,000. And once we had the agreement in place, the defense attorney called me up and said, "Can I send you the check?" And I said, "What do you mean?" And she said, "Well, I assume you're just going to take the low because you're going to lose at the arbitration." And I was sort of taken aback by that, because I never would think that. And so we, in fact, went forward with the with the binding arbitration, and we got a judgment for $850,000. So I don't know if anybody else has had that experience, but I'm here to tell you that don't take the money. Do the work. Do the work. There's a question in here. I'm sorry.
Hold on just a sec. There's a it's time for the second code, if I may, and the second code is injury, INJURY, injury. And I wonder if I could take the host's privilege here and ask Gary, one thing that I'm picking up very, very strongly as a difference between the kind of mediations that you get involved in and the kind of mediations that I and other people on the call get involved in. An awful lot of companies who get involved in a commercial dispute or a contract dispute or an employment discrimination claim, it's important for them to resolve it early, because what they're trying to do is to avoid both risk and cost of going through full-fledged discovery. And if they could deal with this thing now, they call it moving the needle to the left. They assume they're not, ultimately, statistically, they're certainly not going to go to trial on the thing. So the question is, how much money are they going to spend before they settle the claim? By absolute contrast. I'm getting a sense from you and Craig and the judge that you guys are doing this, about the time that the jury's impaneled. You've already had expert reports, the depositions, and every other damn thing, and you're about to pull the trigger. Is there no consideration in your clients of trying to manage the risk? I'm talking from a defendant point of view, trying to manage the risk so that the transaction costs are not as phenomenally high as they can be.
And I'll tell you that the costs have been rising dramatically as we see expert fees have escalated. When I started, the typical expert charged $2 to $2.50 an hour. I was actually talking to Craig earlier in the day. I have neurosurgeons who are charging $1,500 an hour now to serve as an expert. So those costs are absolutely a factor. But because of the report and the type of work that I do, where I represent healthcare providers, because there are reporting issues at the end of it, and those reporting issues are so significant that it could be the end of a career for a physician. So you have a very big settlement or verdict that gets reported to the National Practitioners Data Bank. The National Practitioners Data Bank is reviewed by your medical malpractice insurer. They may throw you off of your policy, and you may not be able to get medical malpractice insurance to continue your practice. The health insurers who you have a contract with to see their patients, above a certain level, if you settle or get a verdict, they kick you off their panel, so you no longer get paid to see their patients. Horizon, AmeriHealth, Aetna, all of these companies do that. The Board of Medical Examiners reviews every settlement or verdict. Today, I got a letter from the board for a doctor on a case that I settled for $100,000, a number that I consider to be de minimis, and the Board of Medical Examiners asked us for a narrative describing what that case was about and why we settled it. So the consequences of not working up a case to see if it's one that has to be settled or go to trial is crucial for the doctor. So that's why these policies are so expensive. Your typical obstetrician can pay $250,000 a year for their insurance policy. The litigation is expensive, but the doctors don't readily consent. So, in the appropriate case, it's done early where there's clear liability. But most of my cases are not that clear. So it is on the eve of trial or close to trial. Typically, it's after expert reports have been served, and sometimes before expert depositions, but often after expert depositions before trial. So yeah, we work up these cases all the way through, usually.
I am currently working on several cases that were related to the same institution, where before we filed suit, we had extensive interactions with the risk management team at the institution, where they promised that they were going to adjust these claims early and fairly. And I am now as much as 10 months into litigation on these cases, and I still haven't had an offer. They've acknowledged the negligence. They've acknowledged the severe damages, in one case death, in one case a severe brain injury, and nary a whisper of fairness. So I hear Gary when he says sometimes these cases get resolved early, but the trial attorney in me has always believed, and it is now more belief than ever, that I'm going to get ready for trial. And at some point, people are going to realize the train is coming down the track, and maybe we'll get the case settled for a fair amount of money. And if you don't prepare your case for trial, promises aren't worth anything. And I don't think it's Gary, and I don't think it's the judge. I think it's the people back at home office who figure that there's somebody out there who's going to take short money on a big case. And if I'm on the other side of the table, it can happen. There was I'm sorry, go ahead.
No, I'm sorry, Craig, go ahead.
There were some other questions here. One wanted to know about, is publicity a main concern for the defendant in terms of leverage? And I don't know about other firms, but I keep my client's business out of the media. I think it would be irresponsible of me to publish in the media my clients' personal issues, because ultimately when the case gets resolved, and it probably will get resolved in their favor, they will be hit upon, called upon, cheated, abused by everybody that's ever met them, and many people who haven't, until they have no money left. And so not only at the beginning of the case and during the case, when I resolve a case, part of the conversation I have with every client is, I want you to learn the following sentence. My attorney told me I can't talk to you. My attorney told me it's not okay. I can't talk to you. I'm not allowed to tell you what happened, whether there is a confidentiality provision or not. And hopefully my clients listen to me. Sometimes I know they don't. And then they are targets.
There was a question I saw come up on the screen that said, how do you set what your demand is going to be? I'll obviously leave that to Craig, but when I am trying to resolve a case and I'm speaking to the adjuster, the defense, I tell them that one of the main things they have to keep in mind is that the number that they valued it at, that they round tabled it at, they have to keep in mind that one of the elements is post-COVID. Okay. I really thought when I first started mediating in April of 2021, the jury verdicts were going to be post-COVID, were going to be similar to post 9/11, where jurors say, you know, I feel sorry for you, but I had lost, my mother had lost, my sister had lost. Post-COVID just isn't that way. And it's nationwide. It's not just in New Jersey or New York. Right. And, you know, I had a bunch of really good lawyers in my office last June, and we were deciding, like, why is that? And there was a bunch of big verdicts that had just come down. And we agreed upon four things. First one was inflation, right? And we talked about the price of watermelon. And I said, yeah, last June, I went to buy a watermelon at ShopRite and it was $12.99. I said, well, I didn't buy it because you can cut it open, it can be mushy, right? And plaintiff's lawyer takes out a see-through container with 2 slabs of watermelon and the price $15.88. Granted, it was probably from Whole Foods, but it was inflation. The second reason we all agreed upon is the verdicts that are being reported, right? Obviously, you don't hear about the no causes because defense lawyers are supposed to get the no causes, but if the verdicts that are being reported are high. The third and fourth reason I did not think about. One lawyer said, well, Judge, how about the lottery? I said, what do you mean the lottery? They said, well, you know, back in our day, you win $1 million, you thought you'd go to heaven. You know, people won't even play the lottery if it's $1 million. And the fourth reason was sports contracts. And, you know, some of these young athletes that are getting, you know, really big sports contracts. So, you know, I think the pendulum at some point may swing back. But right now, I think claims adjusters really need to factor that in. And another big factor is the venue. Where is your case being tried? Okay, if you're in New Jersey, is it being tried in Middlesex County or Essex County, which are typical plaintiffs' venues? Or is it in Morris County or Somerset County or Bergen County? Now, it's not really as clear cut today, but you know, typically you do have more conservative counties versus more liberal counties, and that all should come as a factor also. But you know, I'll leave that question to Craig. Like, how do you start? How do you give your demand, Craig? Like, how do you get to that number?
So there's several things that go into how I set a demand in a case. The first one is I always have to know what the coverage is on, because in many cases, my demand is driven by the availability of insurance coverage and the potential of getting money beyond whatever the coverage is. But if there's no coverage issue and I'm just looking at it from a purely value perspective, I then have to make a determination what my job is in that particular case. Are we talking about the lifetime care of a person? Are we talking about money which is predominantly going to be pain and suffering type money, which is discretionary to the person who receives it? For instance, I have a case in the office now where my client is a 64-year-old doctor who is riding a bicycle to work and she was hit by a car and she's now in a persistent vegetative state. And so her lifetime care is the issue in the case. There's $250,000 available in automobile coverage, which is nowhere near what is required to care for this poor woman. And so we are investigating claims involving the intersection and claims against the municipality and the state and the county. We're also looking at claims against the manufacturer of the bicycle helmet that she was wearing to see whether or not there is some way we can take care of her. Whether or not her family gets money beyond that is not the issue in that particular case. And in fact, it's going to cost so much to care for her, it's almost superfluous to worry about that additional money. There are other cases which go in the opposite direction, where there really aren't any medical costs that we need to be concerned with. And, one of the examples is the case we presented today. I know there were some questions earlier about additional cancer, testing and stuff like that. I want to be clear, the plaintiff in this particular case never had cancer, never had a suspicion of cancer. There was no indication he was ever going to have cancer, and he will never need to be tested for cancer again. He didn't lose his job. He was self-employed. His wife didn't know about this as it was going on in real time. He was suffering in silence on his own. And what we were trying to accomplish in that case is to give him a fair and reasonable recovery for what he was going through emotionally, both before and after he found out about the misdiagnosis. And that's one of the problems in valuation, because as Gary and I mentioned earlier, we can take a perfectly different position on it. And both of us are reasonable. And then it comes down to art, not science. How are you going to present this story at the time of trial so that the jury agrees with you as opposed to your very learned and experienced adversary? And we go back and forth, and hopefully with the help of a judge like Judge Happas, we're able to reach a number. As I recall, Gary, and you can correct me if I'm wrong, and I don't know if we're supposed to talk about specific numbers, but we ended up fairly close when we resolved the case to where I started, and pretty far away from where the initial offer was.
Yes, because you are a recalcitrant negotiator. Pick a number, and that's where you stick. So it's either I come up to you because you never come down to me. So
there you go. Well, I'll take that.
Yeah, I made the mistake, Gary, of inviting Craig to sit in on a negotiation class that I was teaching at New York Law School. And in the last 10 minutes, I made the double error of inviting him to the front of the classroom and, commenting. And he said, "Don't listen to this man." And then he sat down.
Pretty much. I think I gave your class a dissertation on the power of the word no.
Yeah, something like that.
So there's a question here about litigation funding and how it affects settlements in your cases. I assume that's directed at me. And I will tell you that in my office, it doesn't affect settlements in my cases at all. When we make a determination to take the case, we set a budget, and we live to the budget if we can, and if not, we increase the budget. And we never, ever say to a plaintiff, you have to settle the case because you're risking my money. I find that to be abhorrent to what I do. I don't want my client making a decision about their life and their future because of a risk I decided to take on their case. Having said that, I know I am a unicorn, and in many firms, there will be discussions with the client once there are offers made, not only about the reasonableness of the settlement, but about having to get the case settled so that the firm doesn't lose the money they've invested. And in my office, we have expended as much as, I think, $500,000 on cases which turned out not to be the strongest cases in the world. But once we're dedicated to the case, we're in. Gary, do you have to worry about funding your cases, or does the carrier take care of that?
So depends on the carrier, but most of the carriers that I do work for require that I prepay experts and expenses and then get reimbursed. The problem is some of the carriers think I'm a bank and that I should carry those costs for 6 months before they reimburse me. But it's not as bad as on your side where you carry those costs for the entire length of the litigation.
Gary, how do you feel when the carrier suggests to you that you use the threat of a plaintiff's attorney losing their expenses as a negotiation tactic in resolving the case?
Well, I don't think that ever really happens. At least not to me. I haven't had somebody tell me to make that argument. But I'm conscious of my adversary's costs. And look, the community that I work in is a very small community. There's maybe 150 med mal lawyers on both sides in New Jersey. I know everybody. I lecture to them. I write books for them. I see them every week, although differently today because it's via Zoom. But I do my best to never hurt someone. So I'm conscious of those fees, and I have candid conversations on things on cases where I think I'm going to beat my adversary legitimately, or where I think they have no shot at winning. And if I try a case, I don't expect to lose it. I very seldom lose because I expect to win it. So I'm conscious of those costs, but I haven't had a carrier tell me to use that as a tactic in settlement.
Because I've had multiple defense attorneys suggest to me that I settle out with them and leave the other defendants in the case so that my litigation will be funded. I don't understand that as a concept.
Well, I do, because here's an example. I had a case many, many years ago where the nurse was the target. It was the baby was horribly brain damaged, and the nurse made a medication error, and the doctor made a correct order, but the nurse transcribed it wrong because she wrote it on a scrap paper and not in the chart as she was supposed to. So what ended up happening was he settled with that nurse for a good mid 7-figure number and decided to try it against my doctor because he had funded that case. It was a free trial. You know, he didn't win. He lost as to my doctor. But in a smaller case where you may have a small piece against everybody and you're not really sure about the claims against everybody, because again, not every lawyer, like the judge said, is as talented as you are or as careful in their screening. So there's less of a chance against everybody. If somebody's willing to give you 50 grand to cover your costs, and then you have the free shot against those other defendants, that's a situation that does work in my experience. And I've seen that happen with many lawyers, but that case is worth 250 or 300, which is below your threshold for even looking at the case.
I
So
think
the kids,
that, if I may, I think that what Leslie was asking about was litigation funding in a different sense. A lot of folks are running into, and in a venture capitalist or someone who's seeking to invest,
right.
who approaches somebody like Craig and says, look, I'll just buy the case from you for X amount, and I get whatever is recovered. Craig, has anyone ever approached you with that kind of a deal? In other words, they'll fund your litigation in order to have a right to receive the award?
Not all of it, but yes, I had an attorney approach me probably 10 years into my practice when I first started to develop a reputation, who offered to fund all of my litigation for a piece of whatever it was I recovered in resolution in the cases. Now, he was an attorney. So in theory, if I was a certified civil trial attorney, I'm not sure how the permutations would work. I might be able to do it. In theory, if I was borrowing the money, I suppose I could have done it. But as with many things that have occurred during my career, I thought anybody that wanted to get wealthy on the sweat of my labor was trying to take advantage of me, and I quickly shooed him away.
Yeah.
There was another attorney earlier who had asked me to join his firm, and he wanted to pay me a salary, and instead of the money I was earning on my own cases. And I pointed out to him that I was making more money on my own. And he got mad at me, and he told me I would never amount to anything, and I'd probably lose my license and get sued.
There you go.
I just turned 64, and I think he's dead. So,
all right, look, we're just about at the end, and before we go, I just have been reserving a direct question for Judge Happas. You spent 20 years on the bench, and you've been having a wonderful time watching attorneys work both on, in the courtroom and in motion practice, and now as a mediator. If you had a magic wand, Judge, what would you what change would you make about the way lawyers go about their business? What's the most obvious disappointment, in other words, that you have observed with respect to the attorneys that you work with?
I mean, for the most part, I think the bar is awesome. But I think I think COVID really hurt us, in terms of communication, in terms of respect, in terms of how lawyers, back in my day, and now I'm feeling old, but a handshake was a handshake, right? If I said something, you can take that. You can take it to the bank, right? And I just think a lot of younger lawyers today, they don't get the experience that we had. We sat in courtrooms, right, on motion Fridays and just bounced from one courtroom to the other. And we learned what was right, what was wrong, what the judges liked, what they didn't like. We sat in court and instead of sitting in the library, I was told, go watch an opening by this lawyer, go watch the closing, do this. Because of COVID and a lot of the young lawyers now just want to work at home. They want to work remote, right? And they don't get the experience, and I don't think they're getting the training. So I would hope to think that as we go forward, we're all cognizant of that. And I try to be a mentor. I've always tried to be a mentor, and I'm continuing that because I think if we all take that on, it's a great profession, right? They'd say that there's too many lawyers, but there's really not. And I think I loved being a trial lawyer. I loved being a trial judge, and I love being a mediator, right? I like working with people. So I think for the most part, everybody's great. But I think we have to be cognizant of the deficits that COVID caused, in our profession.
We've come to the end of our evening, and I want to give you um, the third code for CLE, and that's the word settlement. Settlement. I hope everybody has received the CLE submission form in which you put your code words, and if you don't have it, email me at adr@nyls.edu, and I will send it to you. Craig, you really know how to get a good panel going. Gary and Jamie, we were just so privileged to be able to spend an hour and a half with you guys. It really was an exceptional time. I thank the three of you very, very much indeed. And I look forward to seeing everybody again. Our next event is going to be in January for our annual Diversity in ADR Symposium, and then we will have events in February, March, and April of next year. Have a good
Thank you.
holiday, everybody, and thank you again.
Thank you,
Thank you.
Peter.
Well, everybody.
Thank you.